have a question and answer period following it. I guess if you want to ask questions during the presentation, you're welcome to. Just raise your hand and I'll watch. Everything will go through the presentation and I'll watch the job. You've got questions or anything go on. Okay? Sorry, Jen. Here's the mic. Did everybody hear that okay then? Pardon? I don't know how to do the answer anything.
How's that better? We can turn the volume up. I think. Check. So we've gone through an extensive planning and preparation for the presentation tonight. And really what we were looking to do was to provide some background information, first of all, to give everyone an understanding exactly of what HDI is doing, how HDI came into existence, and to present some of the financials that are involved as well, because I know people have questions about the financials specifically. The other aspect that we're dealing with as well is general questions that people have. Certainly feel free to jump in with any questions. We're happy to answer them as we go along. But we have put through the opening, and I think we have an opportunity or responsibility to try to work towards a bit of kindness with each other as we ask questions and certainly as I answer them. And that's the approach that we're going to take now. So, are we going to hit slide 1? There, so we're on the first slide. Is this, so going back to start from the beginning, basically, actually the Confederacy has been working, I'm going to say from time immemorial with respect to coming up with structures and plans to, sorry, yeah, no question? Yes, we didn't know how many people were going to ask for copies, and we didn't want to print a copy. So if you give us your name, we'll either print a copy off before you now, or we'll email one to you. Okay, we'll try to arrange to get one tonight for you. Just going to wait for someone to sit down. For those of you who don't know me, my name is Aaron Kettler, Garibo Yondarli, and I'm from Tyne Mega, and I am Mohawk Wolf Clan. So anyway, to go back to the presentation, the Confederacy Chiefs have been working for some time on the land rights issues in a manner in which they can protect land. And this really was something that the people had pushed forward. In 1991, you'll see that something called the 8 Points of Jurisdiction was put together and drafted. The 8 Points of Jurisdiction was specifically designed to outline areas where the Confederacy Chiefs believed they had what I'm going to call core areas of competency. There's been some discussion going forward on, it's not really just the 8 Points of Jurisdiction, it's all points of jurisdiction, but that 8 points was something that the Chiefs believed and the clan members believed at the time was a good place to start. Importantly, within those 8 points of jurisdiction, one of the points of jurisdiction was land. There was another point of jurisdiction which dealt with treaties and ceremonies, and this is sort of what all tied into the development process. Then moving up to February of 2006, there was a delegation put together to do education about lands. Shortly on the heels of that, we have the reclamation of Gavestano on February 25th. And then the Chiefs put together a group, a technical support group to address these issues. In May of 2006, the negotiations that were led by Dougherty Hogan, Alan McNaught, were successful in having the return of something in the range of 300 acres of land. This is one of the largest land negotiation returns that's ever happened in Canada. It's not that much land when you put it in a frame of reference in terms of all the land that's been taken, but at the time, 300 acres of land was pretty significant. Later you'll see that there is a land rights statement adopted. And as the discussions move forward with the federal government and the provincial government, there was a number of things which we called blue sky discussions. And what these discussions were discussions between the Confederacy, provincial, and federal representatives, which attempted to find solutions to disputes that were arising over land and the development of land. How these issues could be managed from a structural perspective in terms of the government fulfilling its obligations and the chiefs fulfilling what they believe to be their obligations. We actually got out ahead of time. Many of you heard of this whole issue of consult and accommodate. We want consultation and accommodation. Those are cases that came up a little bit later. We were actually sort of dealing with things before the Supreme Court of Canada, our lucky fan and stuff. And we're actually, some of the ideas that we were putting to the federal and provincial governments were reflected later in the Supreme Court of Canada decisions. But it became very apparent very early that the federal and provincial government really weren't that interested in negotiating in good faith. And that's the problem that we've had, and many of you are familiar with, that when you sit down and negotiate with the Crown simply wants what we call rag the puck. They just want to sit there and talk about talking for as long as possible. During the negotiations, there was also discussion about what was going to be the alternative to negotiating. And at the time, there seemed to be only two real positions. Either get out of the land and shut things down, or negotiate. And if the Crown wasn't going to negotiate, that meant that really what we were condemning a lot of people to was going out on the land and protesting. But the problem was that those specific activities were falling on the shoulders of the few. There were some people who were absorbing a significant amount of the responsibility for going out into the land. So we tried to come up with a different model, and this is how, in 2007, the idea of a plan to deal with development came about. The other issue at this particular time was that Confederacy Council was getting bombarded with developers. Literally 10, 20, 15 developers were showing up at the doorstep of council each Saturday, and the council couldn't get through its work because it was dealing with developers. So those were the two different issues that materialized to create this idea of how to deal with developers. The first step was to come up with a plan, and you'll see it up there was the green plan. And it's the picture that basically included most, if not all, of the Haldimand tract, and included a portion outside the Haldimand tract because we wanted to reflect at the time that Haudenosaunee land holdings weren't limited to the Haldimand, and they included the Nanfin. This was presented to the Crown and was not accepted. They wanted no part of any kind of plan that dealt with the entire tract or all of the obligations. So you'll see there that in April of 2007, that the Confederacy accepted the terms of reference for the HDI. There was something in the range of 14 to 24 different meetings that took place during the Welland Canal community consultations. You might remember there was something in the range of $250 million. It was $150 million that the Crown was saying we want to give to the Six Nations people, and in return they had to surrender the land. So that discussion went out to the people. We actually had a number of clan meetings, clan by clan by clan. We actually had nation meetings, and we also had broader community meetings. And after all those meetings had occurred, we had a team of 5 or 6 people who actually were helping do the presentations on those. And consistently, when we put the presentation on how the Crown wanted to settle these issues, this is how the community came back to us. And they said, that anything dealing with land has to move forward on these principles. One, no more surrenders. Two, the land was a priority. Actual physical land and places to grow was a priority. The third one there is that, yes, people wanted to be compensated. They wanted actual money for the past losses. And at the same time, if people were going to go on using Haudenosaunee land, they wanted to be compensated for it going forward. So those four principles were clearly articulated by the community. We circled back on this information, and we took this again to the community a number of times and said to them, is this what you meant when you told us all those different pieces? And there was something in the range of 400 different people that we talked to specifically on this particular issue, who sort of came to, what I'm going to say, came to one mind on these four principles. So that's what we want to move forward with. You'll see the first bullet point there. Any settlement will be clearly documented. The land is still Haudenosaunee land, because this is one of the big issues that we've come up against.
In the Sanderson agreement, that land is no longer Haudenosaunee land because the sovereign rights and our great law have been signed off of it.
That's not true, but I can address it.
It says that in the engagement agreement.
It actually says, if you read the engagement, we can bump up to that slide right now if you want. But if you look at what that agreement says, what the agreement says is that the Confederacy waives reliance on the doctrine of sovereign immunity. It doesn't say that the Confederacy waives sovereign immunity. It says it waives reliance on the doctrine of sovereign immunity.
So explain to us what that means.
That's what I will.
In layman's terms.
So in the United States, you have a different legal system. And the different legal system in the United States grew out of the relationship between what are called tribes down there and the federal and the state governments. So if you can imagine that here we have the federal government, there they have the federal government, here we have the provincial government, and there they have the state government. So the big difference is the state government's down there and the provincial government's up here. Early in American history, the Supreme Court of the United States said, Indian tribes aren't sovereign. But the Indian tribes of the United States are not sovereign. However, the state governments cannot interfere with tribal governments. That is what's called the doctrine of sovereign immunity. That the state governments cannot interfere, cannot sue Indian tribes in the states.
What about Canada? What about Canada? We're dealing
Yeah,
with
because we don't
Canada.
live in the United States.
I know,
We're not
I know.
dealing with the States, we're dealing with Canada.
So in Canada, when the lawyers from New York and California said, we only know this American law, we have this thing called the doctrine of sovereign immunity. Will you waive reliance on it so that we can do our financing? Because the people who are going to finance this project are from the states. They want you to waive reliance on the doctrine of sovereign immunity. They don't want you to waive the doctrine of sovereign immunity forever. Just don't rely on it for this agreement, because we want you to be held to this agreement. So that's the first part. The second part is sovereign immunity doesn't mean sovereignty. Because it gets confusing because of the words that I use. This word sovereign keeps being used over and over again. And every time somebody hears the word sovereign, I can see everybody's back stands up. They're like, wait a second.
Well, yeah, look where we are now because of signing with this sovereign immunity.
I understand completely what you're saying. But we didn't waive sovereignty, because if you look what the doctrine of sovereign immunity actually means, it's an American legal principle that says you don't have sovereignty. That's what it means. It means, so if we're waiving the application of it, or the reliance of it. If you look at the agreement, that's what it actually says. So that's what we did. Yep, Jesse?
We're living in Canada today. Could we stick to Canada's issues around that particular issue, not the United States?
Well, you'll see later in this agreement, this is the trouble that we have in these agreements, because these agreements are trying to accommodate Haudenosaunee law.
But we waived the application of any further Haudenosaunee laws to this agreement or the project and the covenant and the agreement. At no time shall the fellow this agreement or any matter relating to the project be subject to any requirements, taxes, assessments, laws, regulations, orders, rulings, or other enforcements arising from the application of Haudenosaunee laws.
That's right.
So we're waiving the application of our law
No.
on our land.
If you see what it says we're waiving the application of any further Haudenosaunee law. It doesn't say we're waiving the
So
application
what
of
does that mean from
It
this
means
point
that we
on?
got Samsung to
Or
agree.
any new
No,
laws.
we got Samsung to agree that Haudenosaunee law actually applied to this agreement. Because there was a cease and desist order that the Confederacy chiefs put out on the Samsung deal. They said, Samsung, we're serving you with a cease and desist order. We had a Rihanna here who went out and served the cease and desist order. And for the first time in Canadian law, and the first time in Canadian history, and the first time in a Canadian agreement, we got a company to agree that Haudenosaunee law will apply. And that's how we stopped that project, and that's how we brought them to the table, because they had to recognize that Haudenosaunee law applied. They couldn't go ahead.
Anymore.
Well, that was the compromise. Haudenosaunee law will not, there'll be no further Haudenosaunee law applied once we get a deal that provides a benefit to the people. And as long as they stick to the deal, and they comply with all the environmental obligations, and they comply with all the financial obligations.
I don't know if you're seeing, one of the things, Cheyenne, is that the monitoring program and all of that stuff that we do, that's part of Haudenosaunee law, and we still maintain that. We still did all that. The Men's Fire went out and stopped construction at least how many times, Bill? 2 or 3 times on the Samsung project. During this whole thing, we didn't waive our sovereignty, we didn't waive our traditional or treaty rights, we didn't waive our law. We just said that for this agreement, that there would be no further laws applied, meaning no more cease and desist orders, basically. They were worried about it, they were scared of it, they didn't understand it.
Worded like that.
Because you ask a lawyer, Cheyenne, I mean, I totally understand the confusion and the concern, I do. And we're trying our best to explain it, and why we had to use the American terminology, just because it doesn't exist in Canada. Like, try to find that within the Canadian context. There's nothing there that talks about it. So, anyway, I just wanted to reassure you, like, or maybe you can tell me how you think it doesn't exist now. Like, what evidence is there that it doesn't? Because I know for a fact it still does, and I've seen it and I've watched it. We watched it throughout all the process.
Because it says we waive it.
Well, yeah, I know what you're saying. But
We're not waiving sovereignty. The only thing we waived was the reliance on the doctrine of sovereign immunity. And sovereign immunity doesn't mean sovereignty. It means, it's an American legal principle that deals with how states and tribes interact. And then the other part that you have to look to the agreement as well is there's a non-derogation clause in the agreement. If you go further into the agreement, you'll see that nothing in this agreement abrogates or derogates from any rights. So they can't rely on this agreement to say, you've waived your sovereignty.
So what exactly are the benefits to us in these agreements?
All right, we're going to get back to where we started. You want to go to the final one, the 42 million one? NextEra. NextEra is a large power company from Florida. They used to be called Florida Light and Power. They moved very aggressively into Ontario with respect to developing wind and solar. We negotiated a number of agreements that resulted in a total of $7.5 million a year for 20 years, over the 20-year life. Keeping in mind what the community has said with us with respect to benefits to the community, and this goes directly to your point of how do the people benefit. A portion of the money you'll see there annually comes into what we call a land acquisition fund, and that fund is set up just to acquire land for the people. There's another amount that comes in on a lease amount that's $250,000 and a total of $7.5. Yes, sorry, Richard.
$125,000 to buy land where
it can be within the Haldeman tract, but it's not limited to the Haldeman tract. It's just to go into a fund to acquire lands. And the
What you're showing, Confederacy already owns that land, we're trying to get it back, we're not trying to buy it, I don't understand why we're buying that.
So the difficulty is that we have third parties on the land, people who are, and we have a couple of them that come to us, they don't know the history of the land, they don't know how they acquired the land, and they don't know that the Haudenosaunee still have underlying title to the land. It's actually Haudenosaunee land that's never. But we call them, technically the term is an innocent third party. So you can decide whether they're really truly innocent or not. But we've said on a number of occasions that we're not going to dispossess people of their land without fair compensation. So what's actually happening is they're being compensated for their improvements to the land. We're not technically buying the land, but we need a way to move them off of the land so that Haudenosaunee people can come in.
I don't understand why we're doing that, when the federal government will not do that for us, if we're doing that for non-native people that are sitting on our land?
But
I don't understand the reasoning behind that.
because the federal is not going to lead.
$5,000 going to be used to help somebody else.
Well, what we're doing, what we were told is people want land. So if you go back to the first couple of slides, people say we need more
We
land.
wanted them evicted.
Well, that's not what we heard. We heard that they want people off of the land, and we actually heard quite the opposite. We said, people said to us, we don't want to treat them in a manner in which we were treated historically by evicting them or running them out of town. So,
You're only talking about 400 people in all your answers, 20,000 people here.
we actually did 14 different sessions, and the number of people that we got information from was something in the range of 5,000 in total. It's only 400 that actually wrote back on the final one. And this is what the people told us, and this is what we took to council and was ratified through council about getting the land back. So this fan's really loud here.
You're saying that this money is put into a land acquisition fund for the people. But what people? And you're saying you're buying it for us, like who's us? And who's telling you why this land? And why are you asking us, the people, then to go ahead and buy all this land? And like, who has access to all that money to buy that?
Okay, that's a lot of questions. I'll repeat the question. So the question was, who told you to go do this? To go acquire this land? It's actually the chiefs and the clan mothers told us to do this, and specifically the chiefs and council, the Confederacy Council.
Because
So we
don't
took,
know anything about it. That's why we're here.
we take all of these issues to Confederacy Council.
Actually, you don't.
Yes, we do. We do. It's in all of our reports. We have,
Okay, so how can you submit minutes to us then? And for everything, for any decisions that were made last year?
the Confederacy Council keeps their minutes.
Council said we couldn't really submit, we wanted to put them up on the website.
Council said that, my chief asked me for that.
The chief is the one, if you're talking about Senator, he's the one that said no, you wouldn't let us put it on the website.
We wanted to put the minutes on the website, and one of the chiefs, one of the Canadian rights said, no, we were allowed to put the minutes on the website.
So you guys can't be accountable to the people.
We are accountable because we report to council every month.
Well, I was sitting at one meeting where you came in and you sat there and you didn't ask any approval, you told people that you already went and run that whole document.
Because we had already received instructions to go ahead and acquire it. The council had told us to go acquire that land. The council, the Confederacy Council.
The council, how could you do that? That was major.
Because council told, we,
Sorry, Nick. At the chief's council meeting, when we got the issue of land, there was a whole list of different properties that we took to council. And what the council said is they delegated chiefs and clan mothers to hold a special meeting to talk about the issues of land and try and concentrate on what areas they wanted HDI to pursue. That meeting was held, the border at Gate, upstairs, and then they gave us narrowed it down to the areas that we wanted, but they wanted us to pursue in College Industrial and another area that were closer to the territory. And so that's how that happened. You have to, we can look back to the minutes, but that's how we were delegated.
The question was which specific chiefs and clan.
Nobody takes attendance at council. All the chiefs and clan members that were in the city, they agreed.
So you didn't take them to the term block of the board and border? You have this meeting? Do you know who you talked to, Hazel?
Yeah, I have
Yeah,
that.
so you can give us the meetings of those chiefs and clan members that
can tell you that Lake and Gobi and Allen and not, I don't remember all of them offhand, like, because I have to go back and check my minutes, but I know that there are a few there.
How many took your heat?
Sorry?
How many chiefs took your heat?
When you make major decisions on our behalf.
We're not making a decision. See,
Yes, you are.
We're not, well, you have to let me finish and it doesn't help with your point on it like that.
The chief counsel is the one that makes the decision.
No, but you know how it goes. You know,
I do know how it goes. And I tell you that everything that we have done has gone through the process.
How can you make major decisions on our behalf, you know, and that's without the way you're supposed to.
Well,
I think you have an issue with your chief and the plan, not with the chief. Yeah, I agree.
Well, we don't make, so I guess somebody wants me to get back to the presentation.
No, I was just, what are you gonna do with them?
That's a good question. The first land that we acquired was basically farming land. And it's late in the presentation.
Oh, okay.
So one of the issues was food. So we got two different issues that we were told by the chiefs and the clan mothers to focus on. One was food sustainability and two was housing.
Yeah, and then so there's tobacco on all the land, you know, supposed to buy.
There's white corn, there's flip corn.
How much? Out of 3 acres, how much corn is there?
I didn't get the 7
7 acres. 7 acres. It was published right in the newspaper. Chris told her.
So we have another, I don't mean to interrupt, we have a question in the back. There?
Historically, we have a problem, and you mentioned it, you said third party. Who is the third party?
You mean in terms, it's the non-Haudenosaunee people who are living on the land.
They're the second one. The third party is the Crown, and it's the Crown agents that have been screwing us since the beginning. They refuse to uphold the principles of our relationship, and they encourage squatters to come in and you're calling them the third party, but they're not the third party, they're the second party. The
Okay.
Crown is the third
I
party.
agree completely. Maybe we're just different in a second
No,
and third.
no, but this is what the problems I have, is that the analysis of what's been happening to us is not well understood, and we don't share a dialogue on the circumstance that we're in. My objective has been to try and identify a process of decolonization. And people I talk to, that's what I try to raise. And because there's not a dialogue coming from people who purport to be authority figures from our side of the story, and they do not have, or cannot engage in a discussion of decolonization. There's something really fundamentally wrong with the posturing that goes on. And that posturing is, at this point in time, is ill thought.
Well,
We need to have a dialogue that comes to some real fundamental principles as to how we're going to devise a future. At one of our previous public meetings, I asked the assembled throng, including some of these people purporting to be chiefs, how they were going to deal with things equally or equitably. And that question has come up again. What are you going to do with the land? How are we going to challenge ourselves to be fair with each other? And that's really what it comes down to. And when you have people saying, who's chief, and how many chiefs are making these decisions, we don't even have a quorum under principles of Robert's Rules of Order at 10 down there. That